Hey y'all, I'm Kate Bem. I am a family lawyer in Montgomery County, Texas, and I've got some things to say. Remember, I'm a lawyer, not your lawyer. This is purely for public information purposes, but I think I have some insight that I can share that might be helpful to you. Today, I want to talk about child custody cases. There are three primary issues that a court considers when it comes to a child custody case: conservatorship, possession and access, and child support. I want to talk about what those terms mean, how you can learn to use them to your benefit, and how better understanding of them might help you be a better consumer of legal services. Because that's what you are. You're a customer, and it's an important part of this process that you be a knowledgeable customer about what it is that you're buying. First, let's talk about conservatorship. Conservatorship equals decision making. When we talk about conservatorship, we're talking about the right to make certain decisions for your child, the rights that you have as a parent or as a custodian of a child, and also the duties that you have to that child. I'm not going to go through every single right and duty today because there's really too many for me to memorize, if we're honest. But what I do want to talk about are the ones that people fight about the most. First and foremost is who designates the primary residence of a child. Believe it or not, I have people come into my office all the time and they want to talk about who's going to be the primary parent. Well, in the Texas Family Code, that just means that you get to designate the primary residence of a child. Other than that, there's no designation in the Texas Family Code that says that somebody gets to be, quote, primary. So when we talk about who gets to designate the primary residence of the child, that's when we're talking about the primary parent. The next three that we talk about more often than anything, we shorthand them as heads, meds, and eds. We shorthand them that way, one, because it rhymes and it's easy for everybody to remember, but two, because it refers to the rights themselves and who gets to make those decisions for a child. So heads, meds, and eds. Let's get into it. Heads is the right to make psychological and psychiatric decisions for a child. Psychological decisions are usually thought of as things like counseling. Psychiatric decisions is what we think about when we're thinking about psychotropic medication, going to a psychiatrist, and the like. Oftentimes, ADHD medications and also anxiety medications will fall into psychiatric decisions. But whether a child attends counseling will fall into psychological decisions. Though they're listed in the same section of the Texas Family Code, oftentimes it's actually become kind of popular amongst family lawyers to split those two into two separate rights. And then we're going to move on to heads, meds. Meds deals with the right to make invasive medical decisions in a non-emergency situation. Every parent at all times has the right to make invasive medical decisions in an emergency situation. If your kid gets into a car accident and the doc comes out to you in the emergency room and says, look, we need to decide if you want us to amputate or if you want to try to save the leg, that's an emergency medical decision. When we're talking about invasive medical decisions that aren't in an emergency situation, these are decisions that you would make an appointment in order to have that decision made. Surgical decisions, whether you're going to have any type of object that's going to be inserted into your child's body or removed from a child's body, that's going to be an invasive medical decision. Texas courts have held that pulling teeth is an invasive medical decision, so keep that in mind. The last one is EDS. EDS is educational decisions. Does your child have an IEP? Do they have a 504 plan? Are they enrolled in on-level classes, GT classes, that type of thing? Whether your child is enrolled in band or football, also an educational decision, because that happens on campus and is a class that your child is enrolled in. Now, when it comes to these rights and duties, heads, meds, and eds, and who makes the decision of where the child's primary residence should be, the court has the authority to order that one parent make that decision, that both parents make those decisions by agreement, and then the court can order that you can make those decisions independently. Now, obviously, you can imagine that some of those decisions being made independently might kind of create a lot of conflict. So if you get to make independent educational decisions and you want your child to go to private school and your ex wants your child to go to public school, neither of you gets to make that decision independently because there's got to be an answer. What's commonplace in our courts is for parents to agree that there's going to be a tiebreaker, meaning that if the parents can't come to an agreement, then they will appoint, for instance, the child's school counselor to designate what the educational decision will be, or that they will follow the recommendation of the child's pediatrician. The problem with those tiebreakers is that sometimes the parent's tiebreaker doesn't want to make the decision. I mean, you can imagine that in the world of, let's say, medical decisions or psychiatric decisions, the doctor doesn't want to be the one that makes that decision because then they may have some perceived liability if things go wrong. So you have to be really careful about appointing a tiebreaker if you can't agree, because you wind up in a situation where the tiebreaker says, no, thank you, I'm not making that decision. And then you're back to square one. So generally speaking, that's an overview of the concept of conservatorship. Next, I want to talk about possession and access. Possession and access equals child custody. It's the term that's in the Texas Family Code that we refer to where your child spends their time when. Simple, right? In Texas, the standard possession order is presumed to be in the best interest of every child over the age of 3. So what's a standard possession order? I'm going to describe it. It's kind of easier to look at it on a calendar, but I'm going to describe it, so try to stick with me. So the standard possession order means that we have a shorthand term that I'm going to call one parent the custodial parent and the other parent the non-custodial parent. Now, mind you, those terms don't appear in the Texas Family Code, but it's just easier for me to refer to it that way. So the non-custodial parent typically has Thursdays overnight during the school year, and on the first, third, and fifth Friday of each month, from the time school is released on Friday until the time school resumes the following Monday. Now, if there is a holiday or there's a teacher in-service day, then that weekend is usually going to be expanded by that Friday holiday or that Monday teacher in-service day. And mind you, let me back up a little bit. The standard possession order that I'm talking about is the one that typically applies for parents who live less than 100 miles apart. Now, for those of you who live in the Houston area, like I do, the idea that somebody would drive from Pearland all the way to the Woodlands to take their kid to school every Monday morning seems insane. And as a human being, I'm inclined to agree. But this is how the Texas Family Code is written, so that's how I'm describing it. All right, back to the standard possession order. So Thursdays overnight during the school year, where the non-custodial parent typically picks up from school on Thursday and then returns to school on Friday. Then from the time school is released on the first, third, and fifth Friday of each month until the time school resumes the following Monday, again, expanded by holidays and teacher in-service days. Then the parents will typically alternate spring break, Thanksgiving, the first part of Christmas break, and the second part of Christmas break. So here's how it goes. If it's your Thanksgiving break, then you have Thanksgiving from the time school is released for Thanksgiving break until the time school resumes after Thanksgiving break. Then your co-parent has from the time school is released for Christmas break until noon on December 28th during Christmas break. Then your period of possession begins again at noon on December 28th and goes until school resumes after Christmas break. And then the other parent has spring break in that school year. So we alternate Thanksgiving, Christmas 1, Christmas 2, spring break, and then you switch the following year. And then the non-custodial parent typically has 30 days during the summer. And when that non-custodial parent has 30 days during the summer, we have what we commonly call take-back weekends, where the custodial parent gets to designate one regular weekend during the summer and then one weekend during the 30-day extended summer possession by the other parent. Now, your order may be different. It is critically important that you understand how your order reads. Don't follow what I'm saying unless what I'm saying is what your order says. You need to understand your order. So if you already have a child custody order in place and you're watching this video expecting to get an explanation of what your order says, you have come to the wrong place. I'm just trying to help people understand generally what the standard possession order entails. All right? So moving on to the next topic, child support. So I practice in Montgomery County, Texas. My office is in Conroe, and our local courts follow the child support guidelines pretty closely. So I want to talk about what those guidelines are and how it works. The Texas Family Code says that the court should apply specific percentages to your net resources. Now, what do net resources mean? It's not your take-home pay. Oh, nay. Net resources is based upon a series of tax tables that are put out by the Office of the Attorney General. And basically what you do is you line up sort of like you would have done in elementary school. If on this side I make this amount of money gross and I have this many children, this is what my income is going to be, and this is how we're going to calculate this. So for one child, you're going to pay 20% of your net resources to the custodial parent. For 2 children, it's 25%, and for 3 children, it is 30%, and then so on and so forth. And then once you get a ton of kids, we start applying different guidelines, but that's fair. I also want to say that those percentages are based upon you having a single baby mama or a single baby daddy. If you have more than one co-parent, if you've got children with multiple people, the percentages are going to change slightly, but we're not going to get into those today. All right. So September 1st of 2025, the guidelines changed slightly because there is a cap on child support. I don't want to call it a cap. I'm going to call it a cap, but I don't want to call it a cap, because that doesn't necessarily mean that you can never get more child support than these numbers. What it means is that if your spouse makes more than this amount of money, you have a different standard to prove your child's needs. So used to, the cap was $9,200, and it was that way for many years. And so there's a lot of people, especially in my relatively wealthy suburb, who receive max guidelines child support. So if you're out there today and your non-custodial parent is paying you $1,840 a month for your one child, or they're paying you $2,300 a month for your 2 children, do I have news for you? Because that number has gone up. If your co-parent is a high wage earner and they earn up to $11,700 per month, starting September 1st of 2025, the max guidelines child support has changed. So the max guidelines child support at this point is $2,340 for one child, $2,925 for 2 children, and $3,510 for 3 children. Could you possibly get more child support than that? Yes, but it's up to you to prove that your child has needs beyond that number. And there's some circumstances where that's possible. I've certainly been successful in proving it in court before. But I do want to be honest and say that based upon my professional experience, when we start to exceed those numbers, the court is going to be looking for evidence that we're dealing with a very high wage earner and that your child has, for an extended period of time, lived a specific type of lifestyle. And then experience tells me that the court will often order that the other parent pay for specific experiences for that child. So for example, I had a case once where the court ordered that dad pay X number of dollars annually towards the children's birthday party, or that the dad pay X number of dollars annually towards the children attending a summer camp that their entire family had attended for generations, stuff like that. But it's also certainly possible for the court to order that a high wage earning parent pay a large amount of child support simply because that's what's in the best interest of the child. The court can also order below guidelines child support. I had a case once where that was an issue, where mom was an exceedingly high wage earner, like hundreds of thousands of dollars a year. And I don't mean 200, I mean many hundreds of thousands of dollars a year. and dad was earning right at a low six figures number. And under those circumstances, the court ordered that dad was permitted to pay below guidelines child support. But there again, the court held that dad also had to pay certain expenses for the children. And the court's finding was, which I thought was really interesting, that it was important for these children to see their father providing them with material support. And that was an important part of their relationship with their dad, was that they know that he was doing certain things for their benefit and that helped to foster a parent-child relationship between them. So there's a lot of different factors for the court to consider in setting child support. Just know that net resources number and those percentages is kind of where we start, right? Now, one question I get all the time in consultations is, oh, well, my spouse wants to do 50-50 and he says he's not going to pay any child support. And the answer to that question is always, it depends, which is, let's face it, the lawyerly answer to every single question. It depends. Is it possible for a court to order that? Yes. Is it likely? That's another question altogether. And it depends very heavily upon your family circumstances. And that's something that any attorney is going to need to do a pretty thorough investigation of your family circumstances before telling you whether that's even a likelihood. So, conservatorship equals decision-making. Possession and access equals child custody. Most important thing to keep in mind, the standard possession order is presumed to be in the best interest of your child. That means that's where the court begins. And then last, child support, consider the formula. By the way, if you're sitting there watching this video and you want to know how much your child support would probably be, go to the Texas Attorney General's child support calculator. It's what I do. Just Google Texas Attorney General child support calculator, and it's pretty easy to use. And from there, you can probably come up with a pretty clear idea of how much child support you would be paying or how much child support you would be receiving. Again, I'm Kate Bem. I'm a lawyer, not your lawyer. This is just for public information, and I hope you guys have a great day. Good luck in court.